Hello students, welcome to class. Our topic for today's class is types of contract. At the end of this class, students should be able to identify the types of contracts, know termination of contracts, and also the remedies for breach of contract. And we'll be starting off with types of contracts. We have different types of contracts which include 1. Valid contract. A valid contract is an agreement in which the parties are legally bound to carry out their obligations. It is binding and enforceable by law. 2. We have executory contracts. These are contracts in the process of being executed. The contract has not been totally completed. The parties have obligation to carry out, as some things still need to be done before it is totally completed. We also have severable contracts, where a contract can be divided into several parts. Payments for parts that have been completed can be claimed. Whether a contract is severable or not depends on the intention of the parties. We also have illegal contracts. Illegal contract is not only a void contract, but any other contract related to it will also be void if the main contract was strictly illegal. We also have implied contracts. These are contracts which are entered into through the acts and conduct of the parties. The terms of agreement are not shown by oral or written declarations. Next, we have oral contracts. These are contracts entered into through the use of verbal communication or spoken words. They are not documented or written down. We also have voidable contract. Voidable contract is a contract which is valid unless and until the party entitled to void it actually does so. It is a binding contract but may be rejected by the third party. Next, we have executed contracts. These are contracts that have been completed. Here, the duties and obligations of the parties have been carried out and nothing remains to be done. We also have. Now let's move on to termination of contract. Termination of contract means the coming to an end of a contract. A contract can be terminated or brought to an end through the following means. 1. By lapse of time. A contract can come to an end when the period fixed for the agreement comes to an end. 2. Bankruptcy. A contract can be brought to an end when either of the parties is bankrupt. 3. Death or insanity of the party. The death or insanity of a party can also bring a contract to an end. We have 4. By frustration. A contract can come to an end when the subject matter basis of the contract has been destroyed or frustrated by a natural disaster, e.g., earthquake, flood, famine, etc. We also have illegality of objects. If the subject matter is illegal, e.g., prostitution, stealing, or other vices, such a contract can be terminated. And lastly, now let's move on to remedies for breach of contract. There are different remedies for breach of contract, such as award of damages, specific performance, rescission, etc. In court of limited jurisdiction, the main remedy is an award of damages. For breach of contract cases, there are several different types of monetary remedies which include compensatory damages. This is the most common breach of contract remedy. When compensatory damages are awarded, a court orders the person that breached the contract to pay the other person enough money to get what they were promised in the contract elsewhere. For example, suppose you hire and pay someone to clean your house for 1000 naira. but he is unable to do it. Then you search for a new cleaning service, and the cheapest one you find will clean your house for 1,500 naira. If this cost is found to be reasonable, your first cleaner will have to pay you 1,500 naira in compensatory damages, allowing you to get your house professionally cleaned as the contract intended. 2. We have restitution. When a court orders restitution, they tell the person that breached the contract to pay the other person back. In the example we gave earlier, the court will now order the first cleaner to pay you back 1,000 naira, since that is what you paid him to clean your house for. We also have punitive damages. This is a sum of money intended to punish the breaching party, and is usually reserved for cases in which something morally reprehensible happens, such as a manufacturer deliberately selling to a retailer unsafe or substandard goods. Next, we have nominal damages. A court awards nominal damages when there has been a breach of contract but no party to the contract suffered any harm. We also have quantum merit. A court can award one party payment for what they deserve for any work that she or she performed before the other party breached the contract. For example, if the cleaner in the example we gave earlier had cleaned half the house, and then you decide you don't want him to finish, he can demand the remaining 500 naira as quantum merit. Quantum merit is translated from Latin, which means as much as it deserves. Next, we have remedies in equity. A remedy in equity is when the court orders someone to do something. This can also be called injunctive relief. In breach of contract cases, this can take any of these forms. 1. Cancellation. The court can cancel the contract and decide that the parties are no longer bound by it. We also have specific. Now let's look at terminologies used in contract. We have the first one, tender. A tender is an estimate submitted in response to a prior request. This does not amount to an offer. We also have party. This refers to each person or group of persons in a contract. Next, we have minor. Minor is an infant or a child who is under the age of 18. We have damages. Damages is compensation awarded by a court of law to a plaintiff or a complainant who has suffered loss as a result of an act of the defendant or the accused. We also have promissor. A promissor is a person who makes a promise in a contract. Next, we have promisee. This is the person to whom the promise is made. We also have offeror. Now, if you hear me talk about offeror and offeree, the offeror is the person that makes an offer, while the offeree is the person to whom offer is made and he accepts the offer. Next, we have auction. Auction is a kind of sales where bids are made by prospective buyers and the commodity will be sold to the person making the highest bid, usually called the highest bidder. We also have guarantor. Guarantor is a third party who assures one party to a contract of the other person's compliance. Next, we have quantum merit. As we've explained earlier, it means as much as you deserve. And lastly, before we go, let's take a quick exercise. Question 1. List the means by which a contract can be terminated. Question 2. State the meaning of the following terminologies used in contract. 1. Offeror. 2. Offeree. 3. Promissor. 4. Promisee. 5. Tender. 6. Damages. 7. Quantum merit. 8. Conveyance. Next question. List and explain types of contracts. With this, we've come to the end of our lesson. Thank you for watching. See you in our next class. Bye bye.